National Report Court is back in session. For today's case, it's one we told you about yesterday. A 7th grade student in Wisconsin is suing their school district for banning them from the girls' bathroom, despite being a biological boy.
The lawsuit alleges the Elkhorn Area School District violated Title IX and the 14th Amendment by not allowing the 13-year-old transgender student to use the girls' bathroom. Again, a biological boy. We're taking up the case in National Report Court today with Erin Elmore. She's an attorney. Dwane Cates, also an attorney. Thank you both for coming on for this. So today, if you could, Erin, please represent the transgender student who's suing, along with the child's parents, who are also named in this suit, again, for the purposes of the segment only. Dwane, please defend the Elkhorn Area School District. Okay, so let's dive into the lawsuit that we have. The transgender student wants to remain anonymous, goes by Jane Doe throughout the suit. So here we go. Quote, the guidance counselor unilaterally decided that Jane would only be permitted to use faculty restrooms at Eames instead of the girls' restrooms and locker rooms that non-transgender girls can use. Neither Jane nor her parents were given the option that she be able to utilize girls' restrooms and locker rooms like other girls. At the time, Mr. and Mrs. Doe were unaware that Jane could use girls' facilities at school and did not object to his directive. Erin, can you walk us through the case here, legally speaking? Again, the transgender student, what are the options in terms of using the girls' bathroom at this area location?
You know, it's more about what the federal law says here, but unfortunately for the sane and rational and those who care about children's rights, the court will likely rule in favor of the transgender student who at this young middle school age is capable of changing their gender, mind you, but not able to vote, drive a car, get a tattoo, join the military, or drink. Having said that, precedent is what we're talking about. Legally binding opinions that come before have indicated in this federal district that transgender students are allowed to use the bathroom that they identify with, not based upon biological sex. Unfortunately, in this case, courts are bound by precedent. Now, this is federal. So when you get to the, first of all, you start with 94 federal courts, then 13 appellate, and then you have the Supreme Court. So right now, in several different of the 13 districts across our country, there is a difference in opinion on this. That's when the Supreme Court usually has to come in and make a decision. Now, they never have to hear a case, but on this one, let's hope they do, because we have differences, let's say, in Florida versus Wisconsin. But in Wisconsin, where we are for the merits of this case, precedent says this Jane Doe may use the bathroom that she feels identifies with her gender at the moment.
Okay. Interesting explanation there. The Elkhorn Area School District Superintendent Jason Tadlock said he's not comfortable speaking about the specifics of the lawsuit because he hadn't had an opportunity to review it with the district's attorney, but wrote this: we always strive to meet all our students' needs, and I am saddened to learn that one of our students and or parents feel that we are not meeting their needs to their satisfaction. Dwane, can you talk to us about the defense here? Again, the school says we want girls to use the girls' bathroom and we want boys to use the boys' bathroom. For transgender students, they can use a separate faculty bathroom.
You know, and I agree, the courts are going to have to sort this out at some point and get some consistency between the districts. But in this particular case, they've made a reasonable accommodation. They're allowing the transgender student to use a faculty bathroom. Okay, now the logic in this is a little flawed as far as the overall saying that she should be able to use the men's restroom, because, or the women's restroom, because it's like saying, because I get full Title IX protection simply by identifying as a female. That would be the same thing as me saying I should get to use handicapped parking spots because I identify as disabled. Now, I'm not physically disabled, but I identify as physically disabled, so I should get the protections, you know, of the courts in that. And, you know, the courts are going to have to step in and sort this out, because this is, you know, it's a really tough question. I mean, you know, I think they made a reasonable accommodation. I think letting the student use the faculty bathroom is good. I think when they build new schools, if this is still an issue, they're going to have to make a gender-neutral bathroom. But right now, most districts don't have the ability and the money to retrofit every school with a gender-neutral bathroom.
Sure.
So I think their accommodation is reasonable under the circumstance.
All right. And again, the argument at the center of this case is that's not good enough. Again, the biological boy wants to be in with the girls in that restroom. Attorneys, great arguments today. Dwane and Aaron stand by. Wanted to welcome in now Ben Weingarten, senior contributor with The Federalist, going to play judge and jury. He's been listening in. Ben, where do you land on this case?
Well, I agree with both hypothetical attorneys in this case. On the one hand, I think Aaron's right that at least at the lower court levels, judges will probably rely on precedent and what I think is a warped interpretation of Title IX to the extent that's the justification for it. And I also agree with Dwane that on the merits here, we're talking about a more than reasonable accommodation here that doesn't burden, by the way, girls who want to use girls' bathrooms or girls' locker rooms and not have a biological male in those locker rooms or restrooms. Ultimately, I do think maybe this case ends up at the Supreme Court, depending upon how the appeals process works out. And I'm not confident that the Supreme Court is going to land on the side that I do, which is that I'm not bound by precedent here. And I think that ultimately the rational decision is to make a reasonable accommodation. The courts in Bostock, specifically the Supreme Court, has sort of shown a willingness to expand the definition effectively of what constitutes protected classes. And the Biden administration itself has issued guidance saying Title IX now includes gender identity. But think about it at its most basic level. Sex is an objective standard that we can point to. Gender identity, to Dwane's point, is a subjective standard based on sentiments and feelings, however earnest and in good faith they're put forth. But you can imagine the kinds of absurd cases this can lead to with, for example, the handicap claim, for example, and even beyond that, of course, those who actually have dealt with harm as a consequence of biological males being in girls' locker rooms and obviously in sports and a whole slew of other areas as well. So that's why I think we have to rely on an objective, traditional standard here. And it's not out of a lack of empathy for those dealing with gender dysphoria, but it's about what's fairest for society.
All right. Could this case make it all the way up to the Supreme Court? That would be really wild to see. Attorneys, thank you so much for walking us through this case. Aaron Elmore, Dwane Cates, and Ben Weingarten, our judge. With that, National Report Court is adjourned. Good stuff today. All right.